Good evening. 124th Constitution Amendment Bill that was passed by both the houses of the Parliament has been challenged in the Supreme Court. Of course, today the bill has been forwarded to the President of India for his assent. At any point, at any time from now, the President will be giving assent and the bill is going to become an act. And we know that this bill is basically meant for providing meant for providing 10% reservation to the economically weaker sections in the general category. Fine. So now, with respect to this particular bill, as we discussed earlier, this may be challenged in the Supreme Court. Today, there is an organization called Youth for Equality, and that organization fights against the reservations. That organization has challenged the validity of this particular bill. Fine. So, according to this particular organization, as we discussed earlier, this particular reservation is violating the principle of equality as enshrined in the Constitution under Article number 14. And once this amendment becomes an act, once this bill becomes an act, there is going to be two articles that are going to be inserted in the Constitution. Article 15, Clause 6 and Article 16, Clause 6 are going to be inserted. So this will pave the way to provide reservations, 10% reservations to economically backward sections within the general category. But here, the point for us is that what are the various case laws that are coming into the picture that is important. And these case laws you have to mention in the examination, right? In the earlier class, I told you regarding Indira Sahani case of 1992. And I also mentioned about 1973 Keshwananda Bharati case. So depending on the judgments that are given by the Supreme Court, in these cases, this can be very much challenged, and the Supreme Court may take up this particular case for, this hearing. What is going to happen, that we need to wait and watch. And I told you already that you are expected to follow this very clearly and carefully, right? Meanwhile, the president may give assent and this particular bill will become an act. And for the examination point of view, I would like to tell you one thing. Once the Constitution Amendment Bill has been cleared by both the houses of the Parliament, as it was cleared in 124th Amendment Bill, day before yesterday, that is on January 8th, it was cleared in Lok Sabha, and January 9th, it was cleared by the Rajya Sabha. And today it has been forwarded to the President of India. Now the point is that whether the President of India can send back the bill for reconsideration. Please remember, answer is no. Since it is the Constitutional Amendment Bill, President has no power to send back the bill for reconsideration, and the President must give the assent. This is the point you have to remember. Now, why this particular provision has been added to the Constitution? Basically, in the original Constitution, just like ordinary bill, President was permitted to send back a Constitution Amendment Bill for reconsideration. But over a period of time, in the year 1971, when Srimati Indira Gandhi was the Prime Minister of India, she amended the Constitution. And the number was 24th Amendment. Through 24th Amendment, it was made very clearly that if a constitution bill is forwarded to the President of India, President cannot send back for the reconsideration, and the President must give his assent. So that's the reason why this 124th Constitution Amendment Bill is not going to be delayed. That's the reason why I said at any time the President gives the nod and bill is going to become an act. But the interesting and the twisting point is that challenge in the Supreme Court, right? So by tonight, if the President gives the assent, it becomes an act. Then Supreme Court may, this take up this for hearing, or that all depends on the discretion of the Supreme Court. what case can be accepted for hearing, and what case, what petition can be rejected by the Supreme Court. Ultimate decision will be taken by the Supreme Court. But when it comes to this particular organization, Youth for Equality, so this is fighting against the, these reservations. That is the reason why with this particular bill, basic structure of the constitution, like, the right to equality has been violated, as we discussed in the earlier class. So Article 14 is coming into picture. Similarly, Article 16 is also saying equality of opportunities among the equality of opportunities in public employment. So when it comes to government employment, equality of opportunities must be provided. But Article 16 Clause 4 is an exemption where the state can provide reservations to backward sections of the society if the state feels that those sections are not adequately represented in the government employment. Clear? And the government today wanted to go in the same line, and it wanted to add another class to this article, and it wanted to say that these economically backward classes within general category should also be provided the reservation. Clear? So once it is accepted by, the judiciary, of course, the judgment may come out very early, and the Supreme Court may constitute a constitution bench, and that may hear this particular case, and we need to wait and watch regarding the outcome. Fine. But it is too early to say all these things. But what is going to happen in the Supreme Court tomorrow, that we need to, this watch very carefully. And I told you already, whatever may be the examination that you are writing, for every examination this aspect is important, including examinations like civil services and, this group 1 services, what you are appearing for. Now I'll open the document and I'll show you the points that are related to, this on what basis it has been challenged in the Supreme Court, and what are the various case laws that have been highlighted by this organization, and these are the judgments that were given by the apex court in the earlier cases. Clear? Right. Now, so now look at this. Look at this. See here, when you're writing exams like, civil services, or, descriptive type like a group 1 examination, mentioning case laws is very, very important. Look at this. 124th Constitution Amendment Bill was challenged in the Supreme Court today. That is January 10th, 2018. Right? And the petition was brought by Youth for Equality. Right? And it said that 124th Amendment violates several basic features of the Constitution. You know what is the meaning of the basic features of the Constitution. I explained you very clearly during our Indian polity classes, and I also explained you day before yesterday regarding this. This amendment, which introduces Articles 15 Clause 6, 16 Clause 6 into the Constitution, they are going to violate the equality code of the Constitution and is in breach of the basic structure of the Constitution. So this is the claim that is made by this organization. Look at this. It also said that it was in violation of the equality of code of the Constitution, which is breaching the basic structure of the Constitution. And the petition also raised some important questions like the usage of expression like economically weaker sections, where it remains undefined under the amendment, and this is going to be, notified by the status later. And this organization said this type of action is considered to be arbitrary and unworkable. Right? Look at this, very important, this particular paragraph. This organization is, highlighting certain case studies, and it placed 1992 judgment in Indira Sahani versus Union of India case, where a constitution bench had specifically stated that economic criteria cannot be the sole basis for reservation under the constitution. This we have discussed in day before yesterday's class. Let me not go into the details of this. Meaning is simple. In the year 1992, in Indira Zahani case, court made it very clear that economic criteria should not be the sole basis for the government to provide reservations to certain sections under the constitution. Look at this. And other case laws upholding, and of course, in the same case, Supreme Court also said that reservations should not exceed 50%. Is that okay? And that 50% version was upheld by the court in 2006 in M. Nagaraj versus Union of India case. And again, in the year 2018, judgment of Jarnail Singh versus Lakshmi Narayan Gupta were also quoted. Meaning, these are the various cases where Supreme Court has given the judgment. These cases have been highlighted by this organization. And ultimately, what Supreme Court is going to decide, we need to wait and watch. But otherwise, once the president gives the nod, this particular constitution amendment bill is going to become an act. All right. And if the Supreme Court feels that this is considered to be a breach of the basic structure of the constitution, Supreme Court has every right to declare this particular amendment as a null and void. If it is declared so, then whatever the this work that took place in the Lok Sabha and Rajya Sabha, that will go into vain, right? So keep following, please keep following this particular this issue. This is very 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 important for forthcoming interviews, the students who are appearing for the interview this time, and also for every examination and any examination in future. Fine. So thank you so much for being with me this evening, and I'll see you in tomorrow's class with more current affairs. Thank you so much.